Good morning.
Morning, Your Honour.
Yes,
Morning, Connor.
Ms Ward. Good morning, Mr Searle.
The first matter this morning, Your Honour, is essentially a directions hearing in relation to the Stage 2 hearing on backburning operations, planning and execution. I appear with Mr Castleton of Senior Counsel as counsel assisting, Your Honour.
Thank you, Ms Ward. I'll just take other appearances now.
May it please the Court, Woodland for the Commissioner of the Rural Fire Service, National Parks and Wildlife Service and the Forestry Corporation of New South Wales.
Thank you, Ms Woodland.
May it please the Court, my name is Searle, initial for Coroners Act.
Thank you, Mr Searle. I'm just having trouble hearing you.
Can you hear me now?
Yes, I can.
Okay,
Thank you.
I'll sit
Could you
closer
just
to the
repeat?
microphone.
Could you just repeat?
My name is Searle, initial A. I appear for Ms Corinne Sheaves and Mr Jochen Spencer.
Thanks very much.
Your Honour, by way of update, an issues list in relation to this Stage 2 hearing has circulated, and I understand that Your Honour should have a copy available to you there. That is a document which provides context to the Stage 2 hearings that will be conducted in May of this year, being hearings into two particular backburns as representative examples of broader systemic issues that might be thought to arise across a range of matters in the 2019-2020 season. So Your Honour will see from the issues list there are three particular questions posed in relation to the Grose Valley Mount Wilson fire, and then there are three particular questions posed in relation to the Currawong cluster of fires, but more particularly within that cluster, the focus is upon the Currawong fire and in particular a strategic backburn near Porters Creek Road in Yata. That's Y-A-T-T-E, separate word, Y-A-T-T-A-H. The issues list also seeks an update on any response to recommendations 47 and 48 made in the New South Wales bushfire inquiry. That issues list is important for today's purposes because it provides guidance to a resolution of an application that's being brought by the Grose Valley Affected Owners Group, two members of which Mr Searle represents. Your Honour, it's accepted that the people directly affected by the Grose Valley Mount Wilson backburn have a genuine and legitimate interest in pursuing evidence going to the planning and execution of that strategic backburn, which was implemented on 14 December 2019. They no doubt have genuine and legitimate interest in other matters as well. That would be entirely understandable in the circumstances that they've all endured. But ultimately, of course, it is a matter for Your Honour to determine the scope of the proceedings before you. When the matter was before court on the last occasion, I had tried to encourage the representatives for the affected landowners to formulate their application and incorporate it into a single document so that Your Honour could clearly understand what category of documents are being sought without having to traipse through underlying correspondence. That hasn't happened, so I understand that Your Honour will be asked this morning to move through a series of correspondence, at least 2 letters, quite possibly more, in order to understand the nature of the documents that the residents group are actually pressing for. To the extent that I understand the correspondence that Your Honour's received, and I think my instructing solicitors have provided, Your Honour, thank you, Your Honour, with a copy of the relevant correspondence. My understanding of the correspondence that you'll be taken to is that Your Honour may also need to be taken to particular pages from the Grose Valley brief and the Gospers Mountain brief. Those pages haven't been extracted for Your Honour, but if learned counsel for the affected property owners can identify those pages with particularity, we might be able to, well, I'm sure we'll be able to find the hard copy version of those documents that he needs to rely on in support of his application. So in the usual course, I would anticipate, Your Honour, we'll shortly hear from the applicant, then from the Rural Fire Service in response, and then we might have a position to assist Your Honour at the close. But can I firstly say, the letter that we received late yesterday, I think it was late last night, or certainly after close of business yesterday, suggested that Mr O'Donnell, the author of the factual investigation report for the Grose Valley backburn, would be included as a witness in these proceedings. It's not presently intended to call Mr O'Donnell to give further evidence in these proceedings for this reason. The factual investigation report for the Grose Valley Mount Wilson backburn was prepared, is in a version and using a template that was used in many of the fires that Your Honour has considered across the season. On my reading of those reports, not just the report for the Grose Valley backburn, it seems that those documents and that template was largely used for internal purposes within the Rural Fire Service. Ms Woodland will correct me if I've got that wrong. As a form of an early review of what had happened in the course of particular significant fires. Paragraph 1.1 of each of those reports sets out as an objective that the report is to establish a factual sequence of events inclusive of relevant circumstances prior to and during the incident that is being particularly considered in each factual investigation report. So they're not an expert report prepared for the purpose of litigation. They are, in my submission, akin to something that Your Honour might see almost in a root cause analysis report in an inquest inquiring into a hospital death. Those root cause analysis reports are, of course, frequently provided to the court, although not admissible in evidence, but they're frequently provided to the court to explain, for instance, a hospital's investigation into a relevant death. The report is also akin to the child death review report that the court routinely receives in matters where the Department of Communities and Justice, Family and Community Services have conducted their own review into a particular death that Your Honour might be investigating. So the report is akin to any number of internal investigation reports that might be prepared for internal purposes but are often sought pursuant to Section 53 order or pursuant to a subpoena if the court is investigating these proceedings. They can be useful documents because they help the court understand the organisation's thinking around what went wrong. But what matters for the purpose of these proceedings is what Your Honour ultimately thinks, not the conclusions expressed by Mr O'Donnell. Your Honour is the fact finder and this court is the tribunal of fact. So we take the O'Donnell report as an initial summary of the RFS thinking around what happened with this strategic backburn, and we brief it to the independent court-appointed expert, Mr Conway. He's read it and he's read a lot of other material besides. Mr Conway's report refers in many parts to relevant witness statements and source documents that have been obtained from the Rural Fire Service. In fact, it was Mr Conway's review of documents first briefed to him that then prompted the council assisting team to seek the production of further documents from the Rural Fire Service. So Mr Conway has considered the documents that he requires for the purpose of his report, and we've been able to pursue and obtain those documents. So the Conway report moves beyond anything in the O'Donnell report. It is independent and it is informed by matters that were not referred to within the O'Donnell report. The Conway report also extends to issues that the O'Donnell report was not asked to consider. So the court will hear evidence from Jeff Conway And the court will also hear evidence from the people who were actually involved in the decision-making at the time. Rather than O'Donnell's interpretation of what these people did, Your Honour can anticipate hearing evidence directly from some important witnesses, such as Mr James Carter, the RFS Divisional Commander for the Bell Division and the involved in strategic planning for the backburn. We're waiting on an additional statement from Mr Carter, and I'll shortly invite Ms Woodward to give us an update on when we might expect that statement. We've been waiting for it for some time. And I emphasise Mr Carter because in the correspondence that was received on behalf of the affected landowners yesterday, a submission was made about needing documents that Mr O'Donnell relied upon in order to understand what the strategic planner did in the course of planning for the backburn. Well, rather than bothering with what Mr O'Donnell might have understood the strategic planner did, Your Honour will hear from the strategic planner directly. It's likely that the witness list, let me get that right, will also include Kenneth Pullen, who is a group captain and responsible for planning within the IMT, Mr Craig Burley, the Hawkesbury District Group Captain and Division Operations Lead, and Mr Chris Banffy, the National Parks and Wildlife Service Park Ranger and Aerial Attack Supervisor. There will likely be other witnesses that will come onto the witness list. That's not circulated yet because we're still waiting on outstanding material. But it might be sensible that we just serve that list in draft now so that we can ensure that everyone understands the actual and most important witnesses that you will hear from, which will be the people that were on the ground making decisions at the time, rather than the people who later conducted an in-house review. Those witnesses should be prepared to answer questions as well as they can around their decision-making. And if that involves access to material that's not yet in the brief, the legal representatives for the state agencies will presumably see to that because it's in their client's interest that their witnesses are properly prepared. To this end, can I also indicate that it is likely, Your Honour, that the 2 weeks presently set aside for hearing dates will be largely dedicated to this case study, so to Mount Wilson and to Currowan. We had initially, the hearings had initially been conducted in a way that they would be largely restricted to 5 days, even 4 days at one point, in order to hear evidence and opening submissions in relation to the 2 separate fires. What's presently proposed is that more days will be available during that May block, so that the Mount Wilson and Currowan fires can proceed to conclusion, opening submissions through to concluding by way of oral submissions at the end of that time period. The only day that's not available in that 2 weeks is a day that's been set aside to conclude the good inquests. So this is to everyone's advantage that we will start the hearing and finish the hearing in one block, and Your Honour will be able to consider the evidence from the decision makers on the ground and the evidence from the expert and any expert that might yet give a report on behalf of the affected property owners. And the matter will then come to conclusion in that period in May. So we found more time. We will then need to speak to the parties about a process for written submissions on the outstanding matters and the possibility of some July dates, but the July dates being referred or reserved for council assisting submissions in reply. There would be a series of written submissions and submissions in reply from affected parties or sufficient interest parties in relation to the outstanding stage 2 case studies. Now that's a lot of information that I've imparted in one short space of time, and we will certainly be in contact, most particularly with the RFS, because we understand we'll need to speak to them about proposals for July. But at this stage, the plan is that we will use as much time as we can in May to start the backburn case study and finish the backburn case study in the time that's presently set aside. That's all that I wanted to say in reference to the application, but I'll now let Mr. Searle make the submissions he wishes to make in support of the application on behalf of his clients.
Yes, Mr. Searle, on the application.
Thank you, Your Honour. I thank Council Assisting for that useful framing. I would just want to start with the Stage 2 hearings issues list that was circulated. The interests I represent take no issue with that issues list, and in fact, the requests for additional documentation in this application fit, we say, entirely within the scope of the intended scope of the Stage 2 hearings, and in particular, in relation to that issues list, fit within paragraphs 11 to 14 and possibly 18 as well. So I just wanted to give the court this assurance that the information being sought by the affected residents doesn't seek to widen or change the proposed scope of the Stage 2 hearings whatsoever, but is very much squarely within the frame of that intended conduct of the Stage 2 hearings. There are a lot of letters going backwards and forwards that discuss the scope of the request, but there are three in particular. There's the letter from my instructing solicitors of 9 March 2023 to Mr. Lincoln Chi, and that was in request for submissions in support of the application. And there's a few pages, 3 pages of that letter. I won't read it, but that's essentially the submissions in support of the application. There's a letter from the Crown Solicitor's Office representing the RFS of 4 April, a 2-page letter, essentially responding, as I understand it, to the application. And then, as Council Assisting outlined, there is a letter of 5 April yesterday from, again, my instructing solicitor, as it were, in reply to what the RFS had to say in its 4 April letter. If Your Honour, I might briefly just move through the different categories of request, and then there's one outstanding issue, which is the filing of evidence for my clients, which was said to be the 7th of April, and of course that's Good Friday, but I'll come to that issue subsequently, if I may. I won't read laboriously all the submissions that have been made in writing. Your Honour can read those, but I might deal with the different categories by reference to the RFS letter of 4 April, if I may. Your Honour may recall that there was a letter of 1 February 2023 with an annexure which set out the specific documents that my clients contended were missing from being referenced in the factual report. Now, just on the issue of the factual report, I understand what Council Assisting has said, that the court will be hearing directly from those on the ground and from decision makers, and that the RFS report, as it were, was an internal document. But nevertheless, those I represent feel it's important to obtain this information, not only to understand how it was that the factual report came to be constructed as it was, but it will also bear on those matters that are contained in the issues list. This information will go directly to those issues as well. So we say that, notwithstanding what Council Assisting has indicated, these documents that are touched on or referenced in the factual report are important, not only to understand the factual report and whether or not, or to what degree it can be relied upon, but also they are important in themselves because they do bear on the questions, the central questions that the Stage 2 hearings are concerned with. If I might just start with the 4 April letter from the Crown Solicitor's Office. Under the first category, the RFS says that it has produced all the relevant documents to the police or the coroner and has asked for the legal basis upon which we seek the documents. Your Honour will know your own jurisdiction much better than myself, but the legal basis is essentially Section 49 of the Coroners Act. We would ask your Honour to require parties to produce information for the purposes of the inquiry. That's the legal basis upon which we say the court can request that information. In relation to the information, I don't want to take up too much of the court's time on this, but it's important to understand the nature of this part of the application. In the 1 February 2023 letter from my instructing solicitor, there was attached a schedule of references that were said to be missing from the factual report. Now, it's very lengthy, but can I say to Your Honour that what my clients are particularly interested in, the missing references, or the references said to be missing from paragraphs 2.8 to 2.12 of the factual report. I believe those are found at pages 159 to 167 of the factual report document. At the bottom of the page, there are two sets of numberings. The larger set, that would be page 159 to 167. And in the bottom right-hand corner, it says page number of, I think 86 is the total. That would be pages 21 to 29 using that series. And just to give Your Honour, if you like, a flavour of what my clients are seeking and say it is missing from the material in the brief, is at paragraphs 29 to 56 of the appendix. And I'll just read out 2 or 3 just to give you a flavour. Now, page 22 at point 2.9, there is reference to, and I quote, in the submission provided by the incident controller and strategic planning officer. Well, what my clients seek there is those submissions. Yes, the factual report makes a certain assertion, but we say that those reports or those submissions are important not just to understanding the degree to which the factual report might be relied upon, but would be important to the court in the stage 2 hearings generally as well. And at point 35 of the request for documents, there is reference to figure 15. There's a figure that's extracted that's in the document, which is page 164. Again, what my clients are seeking is where does that image come from? Is it from another document, or was it created by the author? And I guess going back a couple of pages to page 162, there's again another chart, and just above it, the words, quote, "The options available for the southern containment are described and discussed in the following excerpt from the submission of the incident controller and strategic planner," unquote. Again, so it's an excerpt from a document or possibly 2 documents, and they're obviously clearly relevant to the scope of the stage 2 hearings. And for that reason, those documents are sought and to be placed before the court. I could go through each of those categories, but points 29 to 56 in the schedule to the letter of 1 February pretty much sets out what is said to be missing. And in our submission, my submission, each of those matters are directly relevant to the matters contained in the issues list for the stage 2 hearing. So we do press at least for those missing documents in relation to points 2.8 to 2.12 in the factual report. So that does narrow the scope somewhat, Your Honour. but nevertheless, those documents we say have an important bearing on the court's inquiry into this matter. If I might move on to the second point about the incident action plans. Again, reading the correspondence from the RFS, in relation to that second point, the RFS concludes, quote, please itemise the specific IAPs which you assert are incomplete so my client can assist with this request. So as we understand it, there's not necessarily an opposition, but a request for more information. And in the letter of 5 April, page 2, there is the answer to that query. Now, Your Honour, those instructing me and the people I represent have been to view the documentation in the registry. I haven't myself, but I'm instructed that, for example, the incident action plan for 12 November contains only 1 page. The incident action plan for 13 November, there are a series of single-page documents covering the Northern Division, but other divisions may not be included. The IAP for 15 November again contains only 1 page, and the IAP for 2 December is apparently not there. As is set out in the letter, the IAPs for the dates 11 to 20 November and 2 to 21 December, excluding 16 December, are sought complete sets. Again, they're not only important to understand the factual report, but these documents themselves go directly to the matters that will be the subject of the stage two inquiry. In relation to the third point, the ignition plan, the RFS says the plan is complete. And again, at page 3 of the letter of 5 April, my clients then seek a series of documents which would have informed the development of the ignition plan. And again, these documents and the matters that they refer to would go directly to the matters contained in the issues list, particularly paragraphs 12 to 14, as it concerns the Mount Wilson fire. So these matters, again, are not seeking to broaden or change the scope of the stage 2 inquiry. They fall squarely within the scope of the inquiry as I understand it, and as counsel assisting has outlined. In relation to point 4, the relevance of the ignition plan to the inquiry is apparently said to be not apparent, and clarification is sought. Again, the ignition plans are directly relevant and bear directly on the issues that the court will be inquiring into the stage 2 matters, for the reasons I've already set out. There are 2 more matters in the 5th of April letter, and they're set out on page 3, and that is, and you can see there under the bolded heading, now turning to the remaining documents requested in our correspondence to Lincoln Shee, dated 24 March. Paragraph 3 refers to the overarching strategic plan, and paragraph 4 refers to documentation relating to the approval of the strategy and ongoing approvals. And again, both of those documents, we say, are directly concerned with the matters set out in the issues paper, the issues that stage 2 of these hearings will be concerned with. So we see these documents as being directly relevant and shedding or casting light, if I can use that term, on these matters that the court is inquiring into. They will be important to providing the factual matrix, but also important to understanding the how and the why things occurred and how they unfolded in the way that they did. And they will also, in our submission, be useful then in examining the evidence, or at least some of the witnesses that counsel assisting as outlined will be giving evidence in the matter. The final issue is the issue of the aerial photographs and videos that are sought. In the correspondence, my clients have outlined that at least some of that footage, or some footage, was put on Facebook, and as we understand it, that kind of footage was regularly taken in situations like this. If the RFS says that it doesn't have those, if it doesn't have any such video, well, of course, that is the end of the matter. But nevertheless, it would, given the existence of other footage, not only in relation to this bushfire but others, it would seem odd if it doesn't exist. But if they don't have it, well, they just have to say so, and that would be the end of that matter, subject, of course, to Mr. Banfi, who may be giving evidence. I'm not sure if he is, but he might be able to cast light on whether or not any video footage was taken in relation to that particular occasion. Your Honour, those are the submissions for my clients in relation to the additional documents that are sought. Most of those were set out in writing in exchanges of correspondence, but I've just briefly taken the court to why it is that information is sought. It's not merely to better understand the veracity of the so-called factual report, which is important given that, you know, that's one of the documents that Mr. Conway has had regard to, but these documents also go directly to the issues that the court will itself be examining, and it is important for those reasons. So we do press the application as I've outlined it here this morning. The final matter, which I'm happy to come back to a little bit later, is the issue of my client's evidence, which was said to be filed on the 7th of April. That, of course, is Good Friday. But again, in part because of the lack of the additional material being sought, the expert for my clients hasn't yet completed his report. I understand he is in the process of completing it on the basis of the information he currently has, but obviously he would want the additional information that we seek here today. But in any case, my understanding is he should be able to complete a report sometime next week. So I apologise that the expert evidence and the other evidence that my clients will seek to put before the court isn't ready to be filed today or tomorrow, but my understanding is it will be available to be filed hopefully by the middle or possibly towards the end of next week, for which we do apologise that it hasn't been done faster, but my clients are working as best they can with their limited resources, Your Honour. So those are our submissions.
Thank you, Mr. Searle. Ms. Woodland.
Yes, thank you, Your Honour. May I just first note for the record that while I appear today for Forestry Corporation of New South Wales, they make no submission on this matter and are not seeking to be heard in relation to this issue.
Thank you.
Your Honour, rather than take the court to each individual piece of correspondence, I thought it might be useful to consider the application that's before you today in the context of what I see are three main categories. I think Mr. Searle's requests can be broken down into three broad groups of documents. The first of those is a request in relation to the internal factual investigation report prepared by Mr. O'Donnell. And Your Honour's already been taken to a letter of 1 February 2023, which requests, I think that it's a 34-page document requesting almost a line by line request for documents which underpin that report. Now, my client's response to this request is firstly to agree wholeheartedly with Counsel Assisting's characterisation of this report, in that it was an internal report. It is a template that is used, has been used not just for this fire, and while it contains reflections of the RFS's position on this backburn, it has, we would agree, in effect, well, not been superseded, but it has, the issue has been moved on in light of Mr. Conway's independent report. And given that Mr. Conway has considered that internal report, has referred to many source documents in his report, and has considered any document he requires in preparing his independent expert report, we say that the letter of 1 February 2023 is, well, it's in the nature of interrogatories, and it is not clear to my client the legal basis upon which there is an entitlement to seek those interrogatories. So that's one category of documents that are being sought, and that's our response into those. The second category of documents which, as we understand it, are being sought is, broadly speaking, what has been described as incomplete production. There is an assertion in many of these letters that what my client has produced to Your Honour and those assisting Your Honour are incomplete. Now, my client has spent considerable time revisiting and rechecking its records for what it produced, both in relation to requests by the New South Wales Police during the course of its coronial investigation, and what it has produced to Your Honour and those assisting Your Honour in the present inquiry. And save for one IAP, Incident Action Plan, for the period of 16 to 17 December 2019, which has now been provided, we say that our production to Your Honour has been comprehensive, and to our knowledge, there are no gaps in what has been provided. We say that what has been provided, what has been sought has been provided, and there is nothing further that needs to be produced pursuant to Your Honour's orders. And I must say, significant time has been spent checking that that is in fact the position, and it turned up one document which had not been provided, and we are comfortable, more than comfortable, that that production has been comprehensive. So it's important to understand, Your Honour, that my client has responded to all requests made by Your Honour and those assisting you to date, and will continue to do so. So that deals with the second category of Mr. Searle's client's requests. The third category, as I see it, is really a request by Mr. Searle's clients for documents which fall outside the scope of Your Honour's requests. Now, I've heard Mr. Searle say today that he believes these requests are within the scope of Your Honour's inquiry, but a large percentage of these requests relate to documents or material which is well outside the period determined to be the scope of this inquiry. It involves material well before the decision-making process involved in the 14 December 2019 backburn, and indeed it involves documents which material for a time period much later. So the critical decision-making process of the critical time period that we're dealing with and that Your Honour has sought documents for has been met, and this category of documents sought by Mr. Searle's clients are beyond scope of this inquiry, and it's difficult to see the legal basis of their entitlement to them. That's compounded, Your Honour, by this inter-parties correspondence. Our position is that if the parties Mr. Searle represents are seeking for Your Honour to exercise a power against my clients by ordering the production of a range of additional documents that have not previously been sought, then that application really needs to be regularised. There needs to be some rigour injected into the process, and rather than these documents being sought via inter-parties correspondence, which has the effect of effectively broadening the scope of this inquiry, Your Honour, unilaterally, there needs to be a formalised process whereby the application is made to Your Honour to exercise this power, the legal basis for this power to be exercised, and that needs to be made clear why additional documents are being sought beyond the scope of the current inquiry, as do the specific documents that are being sought. At the moment, it is difficult to ascertain the precise documents that are being sought and or the legal basis of their entitlement to them. So in short, Your Honour, my client has complied with all requests made of it by Your Honour and those assisting Your Honour, and in the absence of a formal application by Mr. Searle's clients for an order that Your Honour exercise a power against us to require additional documents outside scope to be produced, we say these requests are beyond the scope of this inquiry and without legal basis. And those are my submissions.
Thank you, Ms. Woodland. Ms. Ward.
Your Honour, I adopt those submissions from Ms. Woodland about the need for a formalised process so that Your Honour could actually understand what you were being asked to rule on. And we had rather hoped that that formalised process would be today and that there would be an application, perhaps a draft Section 53 order for production, if not in the format of a court form, at least a document which would particularise from paragraph to paragraph the documents that were being sought so that Your Honour could rule. Now, that hasn't happened, and time is getting away. These hearings will run in May. In my submission, the affected residents groups should prepare their statements and serve them next week as is. They should not wait for the production of any further material. The expert should conclude his report on the basis of what he has, and if further material then becomes available, so be it. It will then be possible for the expert to provide an addendum to that report. As for the rest, I'm still not certain, Your Honour, that I understand the categories of documents that are being called for, as one traces through a variety of letters back and forth that have been sent over the course of the last few weeks. And in my submission, Your Honour's not in a position to rule on something if Your Honour can't clearly understand the categories that are being discussed. I'm also conscious of the fact that we've got parties in other matters waiting for us to commence the substantive proceedings today in terms of closing submissions for 2 of the case studies from stage 2. Would Your Honour consider reserving your decision on this application, so-called? It might be possible to try and go through the correspondence and pull together some sort of framework to understand what it is that the residents group are specifically pressing for. And in particular, for example, one would think as a matter of common sense, if the RFS is saying we've produced everything by way of incident action plan, and the affected residents are saying, no, you haven't, we believe documents are missing for these dates, there would at the very least be a table that sets out on the part of the affected residents the dates of the plan, the page of the plan that's available to them, that would then allow the RFS to go through and determine whether or not, in fact, there are 2 or 3 pages missing from any individual plan on any individual date. It needs to be done with some particularity, and it needs to be done with an element of common sense. If it transpires that there's a bundle of documents that might have been produced to the court and ended up being produced in a way that's got pages out of order, or where pages might legitimately be lost in amongst the other thousands of pages that the court's received, it may be that we will ask the RFS to go back and produce a limited number of accident action plans if it in fact transpires that, accepting that they've been produced to the registry, if they haven't been produced to the residents action group in a sense that, in a version that makes sense, then we might need to ask the RFS to produce a second set. But we need to have some particularity around what Your Honour's being asked to order. So there's force in what Ms Woodland says. If Your Honour was attracted to that plan, then Your Honour might reserve ruling on the application so-called today to allow us to then get on and proceed with the stage 2 hearings that are listed for hearing today. And then either later today or at perhaps a later time, Your Honour will rule on the current application, but in the circumstances that, as Ms Woodland has said and as I have submitted, there really needs to be great particularity in the precise documents. And I understand in terms of the documents said to underpin Mr O'Donnell's report, that has been set out in 300 and something paragraphs. But putting that class of documents to one side, it's the next 2 classes that we're most particularly interested in. If there are incident action plans that are incomplete, we need more than to understand a bold assertion or sorry, I withdraw that. It's not a bold assertion. I'm sure the assertion is well made, but we need to know what is said to be missing from individual incident action plans so that there can be a material attempt to make sure that all of those pages are present. So it's about a focus on particularity. That seems to me to be a sensible way for the matter to move forward, given that it is still difficult to understand the precise paragraphs that Your Honour's being asked to have regard to today from various correspondence across the last several weeks.
All right, thank you, Ms Ward. I will reserve my decision on the application so that we can move on to the work we have to do today, and the parties will be notified of when that ruling will be made. Yes, Ms Ward.
Your Honour, we then, if we are to proceed to the stage 2 hearings, we'll need a brief opportunity to bring some other parties into the virtual courtroom and some other parties who are present in court today so that we can move on to those submissions.
And sorry, just going back to Mr Searle's clients, just if the material can be served by next week, 14th of April is Friday. So if that can happen with the material relying on the material that they currently have.
Yes, Your Honour. In fact, as I was going to say, in reply to what Ms Ward said, that work is being undertaken. We're not waiting for any further documentation. Evidence will be finalised and hopefully filed next week. In relation to just the lack of certainty about what is being sought, Your Honour, you'll see in the various exchanges of correspondence, there doesn't seem to be a lack of understanding on the part of the RFS or anybody about what is being sought. So we're obviously happy to have a conversation if there is a lack of certainty in anyone's mind about what is being sought. As I had hoped in my submissions, in relation to that first category, we would narrow what is being sought to points 29 to 56 in the appendix to the letter of 1 February. Just so Your Honour can be satisfied that significant thought has been given to those instructing me about what is being sought from the court. And to take the point I think that Ms Woodland raised, I don't think it's a correct characterisation to say we're seeking to have orders made against any party. And I think Ms Ward might have mentioned a Section 53 notice. I'd rather thought that this matter could be attended to by directions given by either under Section 49, not against parties, but just to persons to facilitate the evidence that is being adduced to the court. That, in my submission, is the better and more correct characterisation of what is being sought by my clients here.
Thank you.
Thank you, Your Honour.
All right, so we need a short adjournment, do we? How long do you think we need?
It wouldn't be any longer than 5 minutes. I think some parties will be waiting outside and we'll just need to dial some other parties in and check the ABL link.
Okay, let's just say 11:05, hopefully. Yes, Ms Ward.
Your Honour, we now proceed to submissions in reply by counsel assisting, but in relation to two separate matters. The first matter that Your Honour will hear this morning is in relation to stage 2 hearings going to cause and origin. I appear as counsel assisting Your Honour.
Yes, thank you. Yes.
Your Honour, my name is Pintos Lopez. I appear on behalf of Essential Energy, instructed by Ms Wilkinson of Spark Helmore.
Thanks very much, Mr Pintos Lopez.
May it please the Court, Rose. I appear on behalf of the Commissioner of the New South Wales Police Force.
Thank you, Ms Rose.
Your Honour, Woodland for the state agencies.
Thank you, Ms Woodland.
Your Honour, on 12 August 2022, the Court directed that, pursuant to Section 32, subsection 3 of the Coroners Act, a general inquiry would be held into the Creewar cluster of fires, the Mount Mackenzie Road Tenterfield fire, and the Gross Valley Mount Wilson fire. The purpose of the case study hearing was to consider the investigation of fire cause and origin undertaken by New South Wales Police and the Rural Fire Service. As a result, these submissions specifically address the following matters. Firstly, the inquiry into the cause and origin of the Creewar cluster of fires. Next, inquiry into the cause and origin of the Mount Mackenzie Road Tenterfield fire. Next, the general inquiry into the investigation of fires by New South Wales Police by reference to the Creewar cluster of fires. And next, general inquiry into the investigation of fires by the New South Wales Rural Fire Service by reference to the Mount Mackenzie Road Tenterfield fire and the Gross Valley Fire Mount Wilson. Your Honour, the Gross Valley Fire Mount Wilson will also be the subject of a further general inquiry into a strategic backburn anchored from the intersection of the Bells Line of Road and Mount Wilson Road. That general inquiry will be conducted next month in conjunction with a general inquiry into a strategic backburn in the course of the Currowan fire. As with so much of the work undertaken in the course of Your Honour's inquiries into numerous fires across the 2019-2020 bushfire season, the majority of the work in relation to submissions for this case study hearing has taken place outside the courtroom. So whilst there might be concerned community members watching online who will today have dialed in to see the culmination of the proceedings, it's important to record that the bulk of the work in terms of submissions has taken place by way of detailed written submissions. So Your Honour has received and will have regard to the following closing submissions already provided in writing. The submissions on behalf of counsel assisting dated 20 January 2023. Then submissions in response on behalf of the New South Wales Rural Fire Service, the National Parks and Wildlife Service and the New South Wales Forestry Corporation dated 17 March 2023. Submissions in response on behalf of the Commissioner of Police, New South Wales Police Force, dated 17 February 2023. And submissions in response on behalf of Essential Energy in relation to the Creewar cluster of fires and the Mount Mackenzie Road Tenterfield fire, such submissions dated 17 February 2023. The matter then is listed today to hear oral submissions from counsel assisting in reply to the written submissions that have already been received from sufficient interest parties. These oral submissions will not repeat the bulk of matters contained in the written submissions. As a result of the exchange of written submissions, a number of draft recommendations have been prepared and they'll be addressed later in the course of these submissions. So firstly, why have these matters been grouped together in this way? The Creewar cluster of fires, the Mount Mackenzie Road Tenterfield fire and the Gross Valley Mount Wilson fire self-evidently occurred in distances that were geographically distant one from the other. The fires also occurred at different points across the 2019-2020 bushfire season. Despite these differences, the matters have been grouped together in this way because each is considered to raise questions about the way in which Rural Fire Service and New South Wales Police conduct important investigations into the origin and the cause of bushfires. The origin and the cause of bushfires is sometimes, I'll withdraw that, the origin and cause of bushfires are also matters relevant to Your Honour's inquiry if Your Honour ever proceeds to conduct coronial inquiries into particular bushfires. But cause and origin investigations are routinely undertaken by New South Wales Police and the Rural Fire Service, even in fires that do not ultimately end up in a report to this court. This might seem like a remote issue for the court to pursue, given that so many of the fires across the 2019-2020 bushfire season commenced as a result of lightning strike. So why consider cause and origin investigations when so many fires were known to have been commenced by lightning strike? But it is an important issue. A careful investigation of where and how bushfires start and of how strategic backburns might be deployed in response to fires that are already on the ground will better inform our understanding of fire risk and fire behaviour. So this in turn will assist in the response to bushfires across coming seasons. This is in addition to the important role of New South Wales Police in investigating all fires, not just bushfires, to determine whether criminal charges should follow. Moving then to the specifics of the inquiry into the cause and origin of the Creewa cluster of fires. These fires started in relative proximity to each other in the far south of the state in January of 2020 and have been grouped together because of their co-location. The three fires within the cluster are, firstly, the Creewa Road Glen Allen fire, which originated in the Snowy Monero local government area, very close to the border with the Bega Valley local government area. This was within the Snowy Monero Police District. The Creewa Road fire was declared out on 2 March 2020. The Postman's Trail Tantawangallo fire originated in the Bega Valley Shire. This was within the South Coast Police District, so different to the Creewa Road fire. This fire was declared out on 4 March 2020. The Big Jack Mountain Road Cathcart fire also originated in the Bega Valley Shire and the South Coast Police District. It was declared out on 4 March 2020. The three fires ultimately merged or coalesced, but as correctly noted in submissions on behalf of the Rural Fire Service at paragraph 5, the fires were never administratively merged within RFS ICOM. That is, the RFS managed the fires as separate fires for operational reasons, even after the fires physically merged. This in turn explains why the individual fires are recorded as having been declared out on different days. Origin and cause of the Creewa Road Glen Allen fire. In written submissions of 20 January 2023, Council Assisting submitted that the court would find that the Creewa Road Glen Allen fire was caused by the fall of a 22 kV steel electrical conductor at approximately 11:17 a.m. on 23 January 2020 after a fallen tree impacted on power lines in an easement running south of Creewa Road near the intersection with New Line Road, Creewa. More specifically, the tree impacted upon conductors in the span in between power poles. I won't repeat the full identification number here, but between power poles that were identified in the proceedings as pole 94 and pole 95. Essential Energy submitted in response that there was insufficient evidence to positively find that the Creewa fire was the result of electrical arcing caused by a 22 kV steel electrical conductor coming to ground after being struck by a falling tree. So a careful review of the documents is required. This is particularly important because, unlike other hearings in which the failure of electrical infrastructure was suspected to have started fires, the Creewar fire was not subject to an early physical examination of the area of origin. The RFS cause and origin investigation, including a scene investigation, did not take place until 16 April 2020, almost 3 months after the fire ignition. There is no criticism made of the delay in that investigation. It was a result of the extraordinary demands of the season. Further, the Creewar fire was not reported to the coroner until May of 2020, and initially an inquiry into cause and origin of the fire was dispensed with. It was only following review of various records by the solicitors assisting Your Honour that Your Honour took the decision to proceed to a cause and origin investigation because of questions around the police investigations into the Creewar fire and the other 2 fires within the group that came to be known as the Creewar cluster. So that is the Big Jack, let me get it right, Big Jack Mountain Road fire and the Postman's Trail fire. So that is the background to the decision to then proceed to a stage 2 investigation in relation to the Creewar fires because of certain systemic issues that were thought to arise on the way in which police investigations had been conducted. Returning then, though, to the evidence that goes to Essential Energy's submissions to Your Honour that the evidence does not permit a finding that the Creewar fire was the result of electrical arcing. The evidence suggests the following timeline. But before I go to the timeline, can I say a summary of early eyewitness account was contained within paragraph 11 of submissions by counsel assisting. I now withdraw that paragraph. As submissions from Essential Energy correctly observe, one can't find a witness account within the brief of evidence that supports the summation of the evidence contained within paragraph 11. In fact, on my review of the entirety of the brief, it seems that the details recorded in paragraph 11 conflated 2 separate accounts and conflated in a way that made the account in paragraph 11 unreliable, so it's therefore withdrawn. I'll clarify the chronology now by reference of the evidence that suggests the following timeline. At 11:17:20 a.m. on 23 January 2020, this is taken from a document at page 113 of the brief, Essential Energy recorded a fault report showing an outage near Creewar Road. This document records an incident type marked as wire down and a description that referred to a 22 kV capital D/capital O, which is probably a reference to dropout, but a 22 kV D/O fuse. Next, sometime around noon, Peter Duncan, captain of the Creewar Rural Fire Brigade, deployed to the fire. Some sparse details about his deployment are recorded in a canvassing report that's at page 89 of the brief. Mr. Duncan was apparently advised of the fire's location by a neighbour. When he got to the scene, he saw fire on both sides of Creewar Road to the west. According to the canvass report, power lines had not come down across Creewar Road, and Mr. Duncan did not see power lines down as they were over the hill from where he was standing. It seems at this time he was appropriately focused upon door knocking to the east to check houses and to see if residents needed to be evacuated, rather than trying to identify the area of origin for the fire. Next, at about 12:05 p.m. on the same day, an entry was included in a Rural Fire Service operation log referring to an incident at Creewar Road, New Line Road, Glen Allen. This is documented at page 102 of the brief. The entry in the RFS operational log seems to refer to a call coming through from 000, which may well be a distinct notice to the notice that Mr. Duncan received, given that he suggests he was first alerted to the presence of the fire by a neighbour. In the course of his later investigation, authorised fire investigator Rain, R-E-I-N, surname Pete, P-E-E-T, also canvassed Richard Blyton, B-L-Y-T-O-N, another Rural Fire Service volunteer. This is also detailed at page 89 of the brief. Mr. Blyton estimated deploying to the scene at about 1 p.m, which is later than Peter Duncan. Mr. Blyton apparently saw a tree over power lines. Only one tree had fallen. One power line had broken and the other power line was pulled down under the head of the tree. The evidence establishes at some point after 11:17 a.m, essential energy crews attended the scene at Creewar Road and, quote, isolated line for RFS, close quote. This is taken from a document at page 74 of the brief. According to the documents, it would seem that David Ingram from the Bombala Depot of Essential Energy was alerted to something at about 1400 hours. His description of the incident is as follows. Lost power on the Nimitabel feeder out of Bombala Z/sub, doing a line patrol and found wires down, possibly tree over line. A fire was burning in the area, unable to access poles. Line isolated. Have not returned to area to assess damage. Spoken to Joe. Now, Your Honour, David Ingram is also the author of the fault report that I referred to earlier in the chronology, having shown a fault being recorded at 11:17:20 that morning and being the fault report included at page 113 of the brief. Mr. Ingram's reference to having spoken to Joe might be a reference to Joe Cullen. In an account provided to the fire investigator AFI Pete at page 103 of the brief, Joe Cullen, Failure Investigations Network Maintenance for Essential Energy, reported that crews responded to Creewar Road, Glen Allen to make safe following a report of fire in the area and tree over conductors. According to this account, attending crews observed a tree over HV or high voltage conductors. The crew also observed a broken crossarm and a broken conductor. The document prepared by David Ingram at page 75 poses this question. Did this incident result in environmental harm or raise any environmental concerns? To which he answered yes. However, on the same page, a later question was asked, did damage occur to private or public property for EE activities or assets? To which he answered no. These entries are raised for completeness, but Your Honour would, in my submission, approach them with some caution, given that they involve the report author clicking on an auto-generated field within an electronic pro forma box, and the court does not have the benefit of a witness statement from Mr. Ingram himself explaining what he saw or did at the scene. Next, in terms of the timeline, we have the fact that by 12:26 p.m, the Creewar fire was authorised as going on ICON. Authorised fire investigator Pete was able to exclude lightning as a cause for the fire and was prepared to exclude other possible causes based upon an absence of evidence of things such as campfire, smoking, debris burning and equipment use, etc. at the scene. This is set out at pages 85 to 86 of the brief. So, Your Honour, in my submission, all of the circumstantial evidence points to the cause of the Creewar fire being the result of a fallen tree impacting upon a 22 kV steel conductor and bringing the conductor to ground. Here, though, the delay in investigation should again be referenced. In oral evidence, Mr. Peat confirmed that his conclusion was purely on the canvassing reports and also from Essential Energy that one wire was on the ground underneath. If I can call that the closest tree, I'm referring to D004. This quote from the evidence of Mr. Peat was given in response to one of the photographs taken from the scene, which is annexed to his report as D004. In his evidence, he went on to say, and the other wire had obviously broken and was lying somewhere on the ground. I don't know where, so it could have very possibly been on top of the other wire or curled up somewhere else. So it would have been arcing with the ground somewhere within that photo on D004. So here, Mr. Peat was emphasising that his conclusion was based upon the canvassing reports and what he observed at the scene in terms of wire and the evidence from Essential Energy that one fire was on the ground. He did not observe evidence of arcing damage at the scene. It is acknowledged that there is force in the submission on behalf of Essential Energy that there was no physical evidence at the site to support arcing as the cause of the fire. That is, there was no physical evidence of arcing on the fallen tree, which Mr. Peat was able to inspect, nor any other evidence of arcing available within the photos taken at the scene or observed by Mr. Peat at the time. It's on this basis that Essential Energy's submission at paragraph 18 was that a finding that electrical arcing has occurred requires positive physical evidence. It is submitted, Your Honour, that that is not inevitably the case. The absence of physical evidence might not prevent a finding that a fire was caused by arcing if, for example, there was an eyewitness to the arc or the fire ignition. Obviously, though, there is no such eyewitness for the Creewar fire. The submissions for Essential Energy then go on to say, with respect, such a finding ought not be made based on speculation about the presence of a downed conductor and its presumed relationship to a recorded electrical fault. This may be accepted. On the circumstantial evidence available, there is a reasonable suspicion that the Creewar fire was caused by the fall of a 22 kV steel electrical conductor at approximately 11:17 a.m. on 23 January after a fallen tree impacted on power lines in the easement running south of Creewar Road near the intersection with New Line Road, Creewar. However, due to the absence of physical evidence or other evidence establishing a definitive cause, the cause for the Creewar fire might be recorded as undetermined. Your Honour, even if the court was satisfied that the Creewar fire was caused by a tree falling upon the high voltage conductor leading to arcing, the evidence does not establish or indeed suggest that the tree that fell was within trimming clearances such that it should have been trimmed under Essential Energy policy as in place at that time. Submissions in relation to the application of Essential Energy policy and the conclusion that Counsel Assisting asks Your Honour to make, that is that the tree was outside trimming clearances, are set out in detail in written submissions from paragraphs 28 through to paragraph 50 and will not be repeated here. Moving then to the Postman's Trail fire. The suspected area of origin of the Postman's Trail fire was not the subject of a scene examination by police forensic officers nor RFS fire investigators, again as a result of competing demands for limited investigation resources. There is evidence within the brief which lends some support to the idea that the Postman's Trail fire was caused by spotting from the Creewar fire. This includes a line scan taken at 7:40 p.m. on 23 January 2020, which showed an area of fire burning separately from the main body of the Creewar fire. Further, the court is aware that other RFS records within the brief of evidence refer to the Postman's Trail fire as being a spot over from the Creewar fire. That was clearly the understanding of the RFS at the time of the fire, although that understanding on their part doesn't establish the fact. Accordingly, in the absence of a scene examination by investigators or other evidence capable of excluding other potential causes of ignition, the cause of this fire is best described as undetermined, despite a reasonable suspicion that it was caused by spotting from the Creewar fire. The fire likely originated in bushland near the Postman's Link Trail, Tantawangalo State Forest, sometime on 23 January 2020. Next, the origin and cause of the Big Jack Mountain Road Cathcart fire. The position is somewhat similar with this fire. Lightning strike data records the presence of lightning in the vicinity of a general area of origin 3 days prior to the first reports of smoke. It remains a possibility that a low intensity fire was caused by lightning strike and it smouldered or burnt in a remote location for a few days before reaching a point where it generated enough smoke to be detected. However, and consistent with the approach taken to other fires in the Creewar cluster of fires, the absence of a witness to the ignition and the absence of a fire scene investigation means that the cause of the Big Jack Mountain Road Cathcart fire is best recorded as undetermined. The fire likely commenced near Big Jack Mountain Road, Rocky Hall, on or around 23 January 2020. Next, moving to the origin and cause of the Mount Mackenzie Road Tenterfield fire. By the close of the evidence in the cause and origin proceedings for this fire, there was agreement between the investigators that the cause of the Mount Mackenzie Road fire is best recorded as undetermined. None of the written submissions on behalf of the sufficient interest parties seek to argue otherwise. The coronial inquiry into the cause, origin and circumstances of the fire was detailed and assisted by expert evidence from Detective Senior Constable Chetham of the New South Wales Police Force Forensic Evidence and Technical Services Command, from Mr Stephen May, RFS Authorised Fire Investigator, and from Associate Professor Trevor Blackburn, who, whilst not an authorised fire investigator, provided important expert evidence in his field as an electrical engineer. The investigation into the cause and origin of the Mount Mackenzie Road fire was also assisted by evidence from a variety of witnesses to the fire in its incipient stages and from different viewpoints. Whilst their evidence did not go so far as to establish a cause for the fire, it did, consistent with the expert reports of Detective Senior Constable Chetham and Mr May, lead to a conclusion that the general area of origin for the fire was a grass verge, about 14 to 15 metres east of 43 Mount Mackenzie Road, Tenterfield. The fire commenced on 6 September 2019, shortly before 1:35 p.m. Systemic matters going to cause and origin investigations arising from the court's consideration of the Mount Mackenzie Road fire investigation will be addressed shortly in relation to proposed recommendations. For present purposes, and noting that so much material is contained within all of the written submissions, I will merely in reply emphasise the following. Firstly, submissions on behalf of the New South Wales Rural Fire Service rightly record that Mr May, and in my submission all of the New South Wales RFS authorised fire investigators who worked across the 2019-2020 bushfire season, should be recognised for their contribution and thanked for their dedication. Secondly, the impetus to push for improvements in bushfire cause and origin investigations should specifically acknowledge the role of volunteers in undertaking important work on behalf of the RFS. This work is, on occasion, physically exhausting and dangerous. As written submissions by counsel assisting emphasised at paragraph 291, The RFS does not have full-time authorised fire investigators employed solely in that capacity, with specific investigations solely in that capacity. Instead, salaried staff or volunteers are authorised to undertake this important work with specific investigations allocated as the need arises. That is, once an investigation becomes necessary, a call-out is made seeking an AFI who might be available to travel to the scene, complete the investigation and prepare the report arising from it. That AFI might also be required to later attend court in order to be cross-examined about the observations contained within their report. So the work in completing the AFI fire investigation report might involve the authorised fire investigators in days of work away from their other employment and away from their own families and their own communities at times when fires might be threatening their own local area. Hence, a debt of gratitude on the part of the community should be acknowledged. Thirdly, Your Honour would be conscious of the fact that during these hearings, lawyers have tracked back and forth through the cause and origin investigations from the comfort of our chambers. And we've also had the luxury of time. In the field, however, demand exceeded supply and decisions needed to be made relatively quickly. According to the evidence of Mark Fulliger, Training Coordinator, Fire Investigation and Compliance Unit, the call for authorised fire investigators far exceeded the number that were willing or available to conduct the investigations across that season. Therefore, a large number of investigations fell to be conducted by a small number of investigators. Moving to the systemic matters investigated in the course of the Stage 2 case study hearings. Written submissions address each of the 18 specific questions that were asked in the Stage 2 case study hearings. Those submissions won't be repeated here, other than to pick up on a discrete point around the manner in which RFS operational decisions impact upon the conduct of cause and origin investigations. The submission will be illustrated by reference to the Mount Wilson Road Gross Valley fire. I have used that name carefully to refer to the fire that was first introduced to the eastern side of Mount Wilson Road as an unintended consequence of a strategic backburn anchored off Mount Wilson Road and Bell's Line of Road. The strategic backburn was undertaken in preparation for an anticipated threat from the Gospers Mountain fire burning to the north and occurred within the Bell division of the Gospers Mountain fire. As submissions on behalf of the RFS make clear at paragraph 16, from the afternoon of 14 December 2019 and throughout 15 December 2019, while the fire burnt in the Hawkesbury Rural Fire District under the control of the Hawkesbury IMT, or Incident Management Team, it was known as the Gospers Mountain Fire, irrespective of whether it was part of the main fire, the backburn, or as a result of the escape of the backburn. Submissions go on to say it was only on 19 December 2019 that the RFS gave the fire burning to the south of the Gross River a new name, namely the Gross Valley Fire. That new name arose because the fire to the south of the Gross River had passed from the control of the Hawkesbury RFS and was now burning within the Blue Mountains RFS district and being managed by a separate incident management team under a separate Blue Mountains Section 44 declaration. So the RFS submissions make clear, to the extent that the escaped backburn fire was burning north of the Gross River, it continued to be managed by the Hawkesbury IMT and was known as the Gospers Fire. That is an important submission, neatly summarising the operational reasons why the introduction of fire to the east of Mount Wilson Road was classified as part of the Gospers Mountain Fire, even though the Gospers Mountain Fire was not then immediately threatening the area. But that submission also illustrates the need for such operational matters to be clearly communicated to New South Wales Police involved in the investigation of the manner and cause of individual fires. Here, the court knows that the officer in charge of the investigation wanted a cause and origin investigation to at least include the scene of the introduction of fire to the east of Mount Wilson Road. Detective Sergeant Laura Harvey asked for that investigation to take place, and then she waited. It was only when she received the resulting report sometime later that she learnt the scene investigation focused upon the introduction of fire to the south of the Gross River, where it then took on the name of the Gross Valley Fire, and did not include an investigation to the east of Mount Wilson Road as she had requested. As submissions on behalf of the RFS make clear, it was the fire to the south of the Gross River that was named the Gross River Fire, managed by the separate IMT under a separate Section 44 declaration. Your Honour, it is accepted that there may be good reasons for the RFS and police to investigate the scene where the fire was believed to have crossed the Gross River and to have entered another LGA under a different Section 44 declaration. The systemic issue explored in the Stage 2 hearings here, though, focused upon why a request from Detective Sergeant Harvey for a scene investigation of an RFS backburn at the corner of Mount Wilson Road and Bell's Line of Road, Mount Tomah, did not proceed. The answer to that question is not established on the evidence. As submitted by the RFS at paragraph 21 of their submissions, it is not clear that her, being a reference to DSC Harvey, that her request was ever understood in that way by anyone at the RFS, probably because of some confusion engendered by inclusion of a reference to the Gross Valley Fire, which the RFS understood to be the fire to the south of the Gross River. But this in itself highlights the importance of better communication between New South Wales Police and the RFS in the course of working on bushfire origin and cause investigations. If anyone, anywhere within New South Wales Police or between New South Wales Police and the RFS, was confused by the OIC simultaneously referring to both the Gross Valley Fire and an ignition point for an RFS backburn on the corner of Mount Wilson Road and Bell's Line of Road, then the issue could have been clarified with the OIC. Here the RFS observe in their written submissions that there was never any real doubt that the spot fire was caused by spotting from the backburn. That may be the case, including for the reasons advanced by the RFS and referring to eyewitness accounts of multiple spot overs at the scene. But the systemic issue moves beyond the particular focus of the fire to the east of Mount Wilson Road. The systemic issue goes to communication between the OIC and those who are conducting a cause and origin investigation, whether cause and origin investigators for police or for the RFS. Your Honour, it is not suggested that every spot over needs to be the subject of a cause and origin investigation. That would be a nonsensical suggestion, impossible to implement. To this end, Counsel Assisting agrees with the submissions made by the RFS at paragraph 32 that the difficulty is in determining what the sensible limits are. Given fires spread by spotting all the time, and in many instances it will be difficult to know whether the spotting occurred from a backburn or from the main fire. Further, even where a spot fire has eventuated from a strategic backburn, that would not justify an origin and cause investigation where it is clear what has occurred and there was no question of the spot over significantly escalating the fire. Instead, the focus needs to be upon a much smaller group of fires, but a very important group of fires, where a spot over from a strategic backburn might have significantly escalated fire damage. To this end, recommendations have been proposed to address cause and origin investigations into this smaller group of fires. Moving then to the proposed recommendations. A number of recommendations were proposed by Counsel Assisting back in submissions of January of this year and subject to refinement by the sufficient interest parties. One of those recommendations is no longer pressed because New South Wales Police have already implemented the proposed recommendation. As a result of the way in which the Rural Fire Service and New South Wales Police have meaningfully engaged with the coronial process the following recommendations can be put forward. I don't know if there is any particular submission in relation to some amendments to the recommendations that I've undertaken. I have attempted to take the written submissions from the sufficient interest parties and reflect them in some refinement of the recommendations, which I'll shortly read. Your Honour, will these recommendations fix everything around cause and origin investigations? No. The recommendations are modest in scope and in effect, but they are worthwhile all the same. So the recommendations are as follows. To the Commissioner of the New South Wales Rural Fire Service and the Commissioner of the New South Wales Police Force, recommendation 1. That in the course of undertaking the 5-yearly review of the Memorandum of Understanding Joint Agency Fire Investigation in New South Wales, consideration be given to A, directly incorporating the provision of State Coroners Bulletin number 22, October 2022. So just bringing up to date the Memorandum of Understanding to reflect Your Honour's current bulletin. B, expressly recording that a bushfire suspected of having started as an unintended result of a strategic backburn may meet criteria requiring a report to the coroner as relating to a safety issue that is of public interest. That means that there is the prospect that such fires, if they are reported to Your Honour, will have independent review by Your Honour to consider whether a further coronial inquiry should be held. C, providing that in such cases where there is suspicion of a bushfire having started as an unintended result of a strategic backburn, New South Wales Police may request modelling from the RFS to consider what might have occurred if the backburn had not occurred. Important information, Your Honour, that puts the decision to set the backburn in context of what was anticipated if the backburn had not been used. D, noting that the officer in charge of any police investigation into a bushfire must be notified, whether by FETS or by New South Wales Rural Fire Service or both, in the event that a cause and origin examination of a particular scene requested by the OIC is not going to occur as contemplated by the request. So to get around the situation for Mount Wilson, where the officer in charge wanted an investigation of Site A and that investigation did not take place. This at least gives the OIC notice of any change in plan about where the investigation will occur, and it gives the OIC an opportunity to advocate for the cause and origin investigation to also include the scene they had identified. Recommendation 2, that the New South Wales Rural Fire Service develop and New South Wales Police participate in an additional incident control online, or ICON, training and awareness session to assist officers from Strike Force Toronto navigate ICON in order to A, locate information earlier recorded for individual fires that later merge and are managed on ICON as one large fire or fire complex, and B, understand RFS naming conventions used when a fire spreads across an LGA or other boundary and is accordingly renamed and managed as a new fire. This is something that is particularly canvassed in written submissions on behalf of Council Assisting and New South Wales Police and the Rural Fire Service. It arises from some observations made by the detectives on Strike Force Toronto as they conducted very many cause and origin investigations across the season. And it reflects the sensible evidence with respect given by Mr. Ben Millington from the Rural Fire Service about firstly, the nature of material that is available in ICON if one knows how to manipulate the system in order to get at the important information, and the reasoning behind RFS procedures for the naming of bushfires, often, for instance, linked to a local land site, local landmark or another site that might be familiar to local residents and alert them to the presence of fire in the area. Next, Your Honour, there is a reduced recommendation directed to the Commissioner of the New South Wales Rural Fire Service, or I should say amended recommendation, taking into account the submissions made on behalf of the sufficient interest parties. So this recommendation, recommendation 3, is as follows: that the New South Wales Rural Fire Service review its authorised fire investigator training and consider providing refresher training to specifically incorporate the following matters. A, that an authorised fire investigator is encouraged, as part of their canvassing, to contact the police officer in charge of a bushfire, investigation, to request any information relating to origin and cause of the fire obtained by the OIC up to that point, and that the OIC is prepared to release. B, that an AFI may advise the police officer in charge of a bushfire investigation of the desirability to seize exhibits if they have not already done so. C, that an AFI is encouraged, as part of their canvassing, to contact private landowners or land tenure managers, such as the National Parks and Wildlife Service, the Forestry Corporation of New South Wales, or Crown Lands New South Wales, at the area where a bushfire is believed to have originated, to inquire about any information which may be relevant to determining the cause and origin of the bushfire. D, that an AFI should include within their report any information obtained at the scene which might bear upon their conclusion as to cause and origin, even if that information is contrary to the final conclusion reached. And E, the appropriate procedure to be followed when an AFI becomes aware of information after their fire investigation report has been finalised, which causes them to change their opinion as to the cause and origin of the fire. Recommendation 4, that the New South Wales Rural Fire Service review Standard Operating Procedures 3.1.9 to A, incorporate matters referred to in recommendation 1C and 3, and B, provide that where it is suspected that a wildfire has breached containment lines or proposed containment lines, leading to a significant escalation of a fire, the FICU should consider 1, asking an AFI to examine the scene of the containment line breach to determine the cause of the breach, and 2, asking the RFS Predictive Services Unit to undertake modelling to consider what would have occurred if the backburn in question had not been done. Next, Your Honour, a recommendation directed to the Commissioner of New South Wales Police. This is a reduced recommendation because the Commissioner has already attended to matters canvassed in evidence last year and has already moved to update the New South Wales Police Force Handbook and related standard operating procedures so that they're now consistent with the, Your Honour's State Coroner Bulletin number 22 from October of last year. So then the next recommendation directed to the Commissioner of Police, which will be recommendation number 5 in total for this stage 2 case study, is that New South Wales Police review any related standard operating procedures to incorporate matters referred to in recommendation 1B through D, which was the joint recommendation directed to both the RFS and New South Wales Police, dealing with amendments to the Memorandum of Understanding. Your Honour, that's all that I wish to say by way of submissions in reply. I'm not inviting the sufficient interest parties to say anything further in submissions, but noting that the amended recommendations document only circulated either yesterday or the day before. If the sufficient interest parties have particular concerns about my refined language, the way that I've drafted the amended recommendations, Your Honour might ask them to give that indication now, and we would then, after court today, have a further discussion about whether there's further refinement required for those recommendations.
Ms Woodland or Ms Rose, would you like to say anything at this point about those amended recommendations?
Yes, Your Honour. The RFS agrees with Councillor Assisting's proposed recommendations and has nothing further to add.
Thank you.
Likewise, Your Honour, the Commissioner of Police has nothing further to add to the amended recommendations.
Thank you, Ms Rose.
I think that's now the conclusion of that stage one, stage two hearing. There are a different group of parties interested in the next round of closing submissions, being bushfire risk classification. So I think, for instance, Ms Rose, on behalf of New South Wales Police, has no interest in those proceedings, and I'm not sure that Ms Woodland is intending to stay on for those submissions or not, given the RFS didn't play particularly an active role in that matter.
Ms Rose, you're excused if you'd like to be.
Thank you.
And Ms Woodland, if you're not intending to stay, you're excused.
If there's nothing else concerning the RFS in the next section, Your Honour, then I don't need to stay.
There are no recommendations directed to the RFS.
Then
So if you'd like to, but you certainly also...
Ms Woodland is welcome, but there's nothing touching upon a client's interests.
thank you, Your Honour. I'll leave.
All right, thanks very much, Ms Woodland.
Your Honour, the parties who are interested in the bushfire risk classification submissions are present in court. I note the time, and Your Honour, staff haven't had a morning tea adjournment. This won't be long. I'm in Your Honour's hands as you want me to, whether you want me to proceed or take an adjournment.
I might just check. Would you like a short break? All good, we'll keep going.
Thank you, Your Honour. Your Honour, these are submissions at the conclusion of a stage 2 case study into bushfire risk classification. In addition to considering the cause and origin and circumstances of the Falford Road Darrawank fire through a stage 1 hearing, the court directed that, pursuant to section 32 subsection 3 of the Coroners Act, a general inquiry be held in order to consider the appropriateness of Essential Energy's bushfire risk classification approach, including the modelling underpinning the classifications, in the lead up to preparing for the 2019-2020 bushfire seasons and as currently applied. The court has received closing submissions provided in writing from Counsel Assisting dated 20 January 2023 and on behalf of Essential Energy dated 17 February 2023. As with the previous case study that Your Honour has just heard, I won't repeat here in detail the submissions the court has already received in writing. Your Honour will see that Counsel Assisting contends for findings and Essential Energy accept it would be open to the court to find that A, the origin of the fire was grass beneath power lines on the southern side of Falford Road Darrawank, approximately 500 metres east of the intersection of Falford Road and Drutt Road, between electricity pole 12480 and pole 34830, and B, the cause of the fire was at least one, but possibly two, tree branches coming onto the power lines at that location, which resulted in arcing between two conductors. Sparks from the arcing dropped into the grass immediately below the power lines, igniting the fire. Your Honour will recall from the evidence that there was no requirement within Essential Energy's own policies at the time to remove or cut back the branch, or possibly two branches, that ultimately fell, because each of them was outside minimum clearance zones. Instead, the Essential Energy Vegetation Management Program provided then and provides now for different levels of vegetation management, such as clearance distances, around power lines or conductors, depending upon bushfire risk classification. Here, the transmission lines identified as the likely cause of the fire were located within an area classified by Essential Energy as bushfire risk classification P2, being moderate risk severity. Under that classification, there was no requirement to keep the area above conductors clear to sky, as would apply in an area with bushfire risk classification P1, being high risk severity. Similarly, there was no requirement under essential energy policy to conduct a pre-summer bushfire inspection on Falford Road. That additional layer of review was reserved for areas with P1 high risk severity classification. These P1 areas tended to be concentrated around the southeastern part of New South Wales, as highlighted within a map contained at page 21-72 of the brief of evidence. It was in these circumstances that the hearing proceeded via expert evidence from Mr. Jason Sharples, Professor of Bushfire Dynamics at the University of New South Wales, and Mr. Paul Demar, Principal Consultant, Natural Resources and Bushfire Management Group. Their evidence was important in raising questions about the modelling which underpinned the essential energy bushfire risk classification, and in particular the Phoenix House Loss Index and the internal fire risk profile regional map. Again, this is addressed in some detail in written submissions and will not be repeated here. Notwithstanding his critique of the analytical methodology employed in the bushfire risk classification used by Essential Energy, Professor Sharples said that even if the limitations in the modelling had been addressed in advance of the 2019-2020 season, it is unlikely it would have resulted in a different bushfire risk classification for Falford Road. The evidence around this topic, Your Honour, is complex. The reason why I'm not attempting to summarise it in submissions in reply is because, number one, these are submissions only in reply, and because, number two, if I try to summarise it, I will get it wrong. The complexity of the expert evidence is set out within the written submissions from Council Assisting and from Essential Energy. The court also heard from Mr. Ian Fitzpatrick, Manager of Network Risk Strategy at Essential Energy. Mr. Fitzpatrick's evidence in response to the matters raised by the experts emphasised that Essential Energy had, understandably, relied upon expert advice in developing their classifications. This should be acknowledged. Further, Mr. Fitzpatrick told the court that their concern was with relative difference in risk across the state, such that the model should still identify those parts of the network which might be multiple times the risk of another part of the network in terms of potential community damage and loss. In submissions on their behalf, Essential Energy seek to emphasise particular matters in response to criticisms of Essential Energy's bushfire risk classification and bushfire modelling as at 2019-2020. So their submissions at paragraph 14 emphasise the scale of the work involved in managing an electricity network across 737,000 square kilometres of the state, almost 90% of which falls within designated bushfire zones. So, Your Honour, as I understand the submission, Essential Energy seek to emphasise that the bushfire risk classification that they use needs to further classify bushfire risk across areas that are already recognised to fall within bushfire zones, so they can target greater resources at areas of greater risk. The submissions of Essential Energy also emphasise the evolving nature of the data and modelling techniques in the field of bushfire risk classification, which is hardly surprising. This is something Your Honour will accept, including because of the evidence from Mr. Fitzpatrick and Professor Sharples about the IGNIS project and its use of fire simulation, economic analysis and Bayesian analysis. Although Professor Sharples favoured the CSIRO Spark bushfire simulator over the Phoenix rapid fire software, it is understood that the IGNIS project can be used with any fire simulation software, and Professor Sharples told the court that the IGNIS project is, in his view, much more consistent with the state of the science. Finally, Essential Energy seek to emphasise the unusually high fire risk across the 2019-2020 season, which is again something that Your Honour would accept. To this end, Essential Energy have given evidence of plans to implement a new system of bushfire modelling for the 2023 fire season, such that criticisms levelled at the previous modelling will likely become redundant. Council assisting sought recommendations addressed to the Chief Executive Officer of Essential Energy in the following terms. I'm just going to summarise them, not set them out in full. So originally, Council assisting sought these recommendations. One, that those undertaking the remodel of Essential Energy's bushfire risk classification system be provided with a copy of the expert evidence of Paul Demar and Professor Jason Sharples, the transcript of their oral evidence and a copy of Your Honour's findings, and that they be tasked to take into account the limitations identified within those documents in developing and carrying out the remodel, so the remodel that Essential Energy are presently hoping to roll out for this fire season. Then recommendation 2, that a copy of those documents also be provided to the Chief Executive Officer of Energy Networks Association to inform the Ignis project team in its ongoing work as they see fit. Your Honour, it's to the credit of Essential Energy that much of that has already been done, rendering at least part of the recommendations sought by Council assisting as OTOs. The expert reports and transcript of proceedings have already been provided to the relevant experts at the University of Melbourne for consideration in their development of the new bushfire modelling. So the recommendations sought on behalf of Council assisting are now refined to say, recommendation 1, that those undertaking the remodel of Essential Energy's bushfire risk classification system be provided with a copy of the court's coronial findings. And recommendation 2, that a copy of the expert evidence of Paul Demar and Professor Jason Sharples, both reports and transcript, along with a copy of the court's coronial findings, be provided to the Chief Executive Officer of Energy Networks Australia to inform the Ignis project team in its ongoing work as they see fit. Your Honour, again, that short amendment to the proposed recommendations first flagged in submissions by Council assisting in January is something that I worked on last night, and their representatives for Essential Energy have not had an opportunity to consider it in any detail. But they are modest amendments, and I'm hoping that they don't cause any difficulty.
Mr. Pintos-Lopez.
There's no difficulty, Your Honour. We're grateful to my learned friend for those recommendations.
Thanks very much.
Now, Your Honour, that marks the conclusion of the inquiry into the cause and origin of the Creewar cluster of fires and the cause and origin of the Mount Mackenzie Road Tenterfield fire. It also marks the conclusion of the inquiry into the cause and origin of the Falford Road Darawang fire, and the conclusion of the general inquiry into the investigation of fires by New South Wales Police, and the general inquiry into the investigation of fires by the New South Wales Rural Fire Service, and the general inquiry into the consideration of bushfire risk classification. In light of what Your Honour determined this morning in relation to an outstanding application arising from the Gross Valley Mount Wilson matter, it's likely that these proceedings will again be relisted for Your Honour to determine a discrete issue at some point, either later today or perhaps in the coming week. So I don't have a formal date to stand the matter over to, but I do note that in terms of substantive hearings, we have hearings set down commencing on, let me get the correct date.
It's 15th of May.
15th of May. So if Your Honour, well, these proceedings have concluded, so on one view there's nothing more to stand over. But the resumption of substantive hearings will be on the 15th of May.
Thanks very much, Ms Ward, and thanks to all the parties and legal representatives. We'll adjourn now. Mr Sell and relevant parties will be notified of the date for the determination of that application, and the substantive matters will resume on the 15th of May. Thank you.
Please stand. This Coroners Court is now adjourned.